In this video, we will see sections of the Insolvency and Bankruptcy Code 2016 which deal with A. Who is an operational creditor and how an operational creditor can initiate corporate insolvency resolution proceedings against the corporate debtor. Who is an operational creditor? Please turn your pages to Section 5 of the Insolvency and Bankruptcy Code, and in particular, Section 5, subsection 20. Operational creditor means a person to whom an operational debt, please note, operational debt is owed, and includes any person to whom such debt has been legally assigned or transferred. So what is operational debt? The definition of operational debt is given in Section 5, subsection 21 of the Insolvency and Bankruptcy Code. Operational debt means a claim in respect of provisions of goods or services, including employment, or a debt in respect of the repayment of dues arising under any law for the time being in force and payable to the central government, any state government, or local authority. So, if you provide me, a corporate person, with goods and services, and I have yet to pay you for those goods and services, then you become my operational creditor. Let us look at this company, JK Coil Coatings Private Limited. As seen from its website, the company deals with coil coatings. As per details sourced from the Registrar of Companies, Mumbai, it is a private company, limited by shares and incorporated on 7th of August 2006 under the Companies Act 1956. It is registered with the Registrar of Companies, Mumbai, and has its registered office in Navi Mumbai in the state of Maharashtra. Now, since JKCC is into coil coatings, it was supplied by a company, Meghna Color Chem, with chrome pigments for manufacturing of paints. Meghna Color Chem is a sole proprietary concern, the sole proprietor being one Puran Singh Vijay Singh Rathod. Now, let's look at the facts of the case. Now, for the goods provided to JKCC, Meghna Color Chem raised 11 invoices whose total value amounted to rupees 35,75,400. The first invoice was dated 7th of July 2017. Now, on 3rd August 2018, JKCC paid rupees 5 lakhs, of which rupees 3,24,314 was appropriated and apportioned towards older debts, that is, for suppliers prior to the invoice dated 7th of July 2017. And the balance rupees 1,75,686 was towards part payment of the first invoice. Thus, the total debt due and payable by JKCC to Meghna Color Chem stood at rupees 33,99,714 as on 3rd of October 2018. Now, after regular follow-ups, JKCC issued a check for rupees 33,35,400 on 25th of February 2019. However, this check bounced when it was presented for payment. The return memo was dated 18th of April 2019. So, the invoice was raised in July 2017. 18th April 2019, almost 2 years hence, Meghna Color Chem has not received any payment from any proper payment from JKCC. So, Meghna Color Chem has now no option but to drag JKCC to the NCLT in order to recover its pending dues from JKCC. Now, since Meghna Color Chem supplied goods to JKCC and has not paid for this, and JKCC has not paid for the supplies, it Magna Color Chem is an operational creditor, as we have seen from the definition of operational creditor earlier. Let us now look at Section 8 of the IBC, which deals with insolvency resolution by operational creditor. Section 8.1 states that an operational creditor may, on the occurrence of a default, deliver a demand notice of unpaid operational debt or copy of an invoice demanding payment of the amount involved in the default to the corporate debtor in such form and manner as may be prescribed. Thus, Section 8 subsection 1 talks of a demand notice. Now, the definition of demand notice is seen in the explanation clause of Section 8.2. It states that for the purpose of this section, that is Section 8, a demand notice means a notice served by an operational creditor to the corporate debtor demanding repayment of operational debt in respect of which default has occurred. Section 8 subsection 2 of the IBC states that the corporate debtor shall, within a period of 10 days of the receipt of the demand notice or copy of the invoice mentioned in subsection 1, bring to the notice of the operational creditor. There are two things which the corporate debtor can do. Either he has paid the debt, in which he has to provide proof, or he has not paid the debt and perhaps show evidence to substantiate the claim that he is unable to pay debt. So, the corporate debtor shall, within a period of 10 days of receipt of demand notice or copy of the invoice mentioned in subsection 1, bring to the notice of the operational creditor A, existence of a debt, if any, and record of pendency of the suit or arbitration proceedings filed before the receipt of such notice or invoice in relation to such dispute, or B, the repayment of unpaid operational debt. How? Number 1, by sending an attested copy of the record of electronic transfer of the unpaid amount from the bank account of the corporate debtor, or 2, by sending an attested copy of record that the operational creditor has encashed a check issued by the corporate debtor. So, after the operational creditor sends demand notice to the corporate debtor, the corporate debtor has 10 days to reply to this notice, either saying that he has paid up or he has not paid up. Now, in Section 8.2a, existence of a dispute, this would mean that suppose I owe you, the operational creditor, a sum of money for the goods provided by you, but I cannot pay you because I have some dispute which is pending in court or before an arbitrator. Before I get the demand notice from you, then I must provide those documents to say that I genuinely cannot pay you until that matter is resolved. As spoken earlier, it's the explanation clause of Section 8 subsection 2 gives the definition of demand notice. Now, a crucial aspect to note in Section 8 is the demand notice, which must be served to operational creditor, must be served by the operational creditor to the corporate debtor, asking him to repay the operational debt which he has not paid when asked to do so by the operational creditor. Now, the proforma for the demand notice is found in Form 3, which comes from Rule 5, Sub-Rule 1, Clause A of the Insolvency and Bankruptcy, Application to Adjudicating Authority Rules 2016. A careful observation of the requirements of Form 3 will show that it mirrors the terms of Section 8 of the IBC. For example, look at point 2 in this form. Amount claimed to be in default and date on which default occurred. If you look at points 3 and 4, they completely reflect section 8 subsection 2 of the IBC. Now, Meghna Kalakem served demand notice in Form 3 on the 12th of September 2019 to JKCC as per the requirements of Clause 8. Now, in order to recover its dues, on the 25th of October 2019, Meghna Kalakem, through its sole proprietor Puran Singh Vijay Singh Rathod, filed company petition CP IB number 3918 of 2019 under Section 9 of the IBC before the Mumbai bench of the NCLT on the grounds that the corporate debtor, that's JKCC, failed to make payment of a sum of rupees 33 lakhs 99,714 as principal as on 3rd of October 2018, which was stated as the date of default. Let us now look at the provisions of Section 9 of the IBC, which deal with the application for initiation of corporate insolvency resolution process by the operational creditor. Section 9, subsection 1 of the IBC states that after the expiry of the period of 10 days from the date of delivery of notice or invoice demanding payment as required by Section 8, subsection 1, if the operational creditor does not receive payment from the corporate debtor or notice of dispute under Section 8, subsection 2, the operational creditor may file an application before the adjudicating authority for initiating a corporate insolvency resolution process. Section 9, subsection 2 of the IBC states that the application under subsection 1 shall be filed in such form and manner and accompanied with such fees as may be prescribed. Now, the form is Form 5 given in Rule 6 Sub-Rule 1 of the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016, which we shall see a little later on in this video. For now, we move back to the IBC. We look at Section 9, subsection 3 of the IBC. It states that the operational creditor shall, along with the application, furnish a copy of the invoice demanding payment or demand notice delivered by the operational creditor to the corporate debtor. Remember, in our case, which we are talking about, JKCC versus MCC, Meghna Kalakem, demand notice dated 12th of September 2019 was annexed by Meghna Kalakem to this particular petition. B. The operational creditor shall, along with the application, furnish an affidavit to the effect that there is no notice given by the corporate debtor, that is JKCC, relating to a dispute of unpaid operational debt. So, Meghna Kalakem sends a demand notice to JKCC. JKCC does not give a reply. So, Meghna Kalakem has also annexed the necessary affidavit of no dispute in terms of Section 9, subsection 3b of the IBC to its petition. C. The operational creditor shall, along with the application, furnish a copy of the certificate from the financial institutions maintaining accounts of the operational creditor. That means Meghna Kalakem will have to annex a certificate from its financial institutions where it has its accounts, confirming that no payment of an unpaid operational debt by the corporate debtor. So the financial statements of Meghna Kalakem will show no payment by JKCC for the unpaid operational debt. And the operational creditor shall, along with the application, furnish any other information as may be specified. Section 9, subsection 4 of the IBC states that the operational creditor initiating a corporate insolvency resolution process under the section may propose a resolution professional to act as an interim resolution professional. Now, in this case, Meghna Kalakem did not propose the name of any interim resolution professional, so the NCLT on its own appointed one Mr. Ramesh Chandra Kumawat as the insolvency resolution professional. We now look at section 9 subsection 5 of the IBC. Now, what has happened so far? On 7th of July 2017, Meghna Kalakem raised 11 invoices to JKCC demanding payment of a certain amount of money. Part of that amount came, the rest did not come. Therefore, in September in 2019, Meghna Kalakem issued a demand notice to JKCC. JKCC did not reply, and therefore Meghna Kalakem was forced to file a petition for insolvency under Section 9 of the IBC. Now, what does the NCLT do right now? So, this is given by Section 9, subsection 5 of the IBC, which states that the adjudicating authority, within 14 days of the receipt of the application under subsection 2, by an order, it can do two things: either admit the application or reject the application. Under what circumstances will it admit the application? It will admit the application if the application made under subsection 2 is complete. That means Meghna Kalakem has attached the necessary documents in the prescribed form and paid the requisite fees. B. There is no repayment of unpaid operational debt. C. The invoice or notice of payment to the corporate debtor has been delivered by the operational creditor. D. No notice of dispute has been received by the operational creditor, that is MCC, or there is no record of dispute in the informational utility. And finally, E. There is no disciplinary proceedings pending against any resolution professional proposed under subsection 4. So, if these 5 conditions are satisfied, then the NCLT will admit the application and communicates the decision to the operational creditor, in this case MCC, and the corporate debtor JKCC. Now, suppose the NCLT had to reject the application under section 9. On what grounds would it reject? It would reject under the following grounds. A. The application made under section 9 subsection 2 is incomplete. That would mean Meghna Kalakems did not fill the required form or left it incomplete or did not pay the requisite fees. B. There has been repayment of unpaid operational debt. That means JKCC would have repaid that amount of 33 odd lakhs. C. The creditor has not delivered the invoice or notice of payment to the corporate debtor. That means Meghna Kalakem failed to deliver to JKCC the demand notice. D. The notice of dispute has been received by the operational creditor, or there is a record of dispute in the information utility. That means JKCC, after it got the demand notice, said that it could not pay the debt because it has some pending case against it. E. Any disciplinary proceedings is pending against any resolution professional. Now, if these conditions were satisfied, the NCLT would reject the application. But before it rejected the application, okay, especially when it comes under clause 2 subclause A, that is the application made under subsection 2 is incomplete, it would give a notice to the applicant, that is Meghna Kalakem, to rectify the defect in its application within 7 days from the date of receipt of such notice from the adjudicating authority. And after it rejected the application, it would communicate its decision to the operational creditor and the corporate debtor. As we can see, the NCLT found that there was a dispute and therefore it admitted the application. So, on 25th of October 2019, Meghna Kalakem, through its sole proprietor Puran Singh Vijay Singh Rathod, filed company petition number 3918 of 2019 under Section 9 of the IBC on the grounds that the corporate debtor JKCC failed to make payment of a sum of rupees 33,99,714 as principal as on 3rd of October 2018, which is stated as the date of default. Now, 25th October 2019 was the date of the petition. On 29th November 2019, JKCC, in its affidavit of reply, denied the contents of the petition and stated that at present some unavoidable issue was faced by the company and hence respondent company could not make payments to its supplier and creditors. Let us look at the observations of the NCLT in this matter. The NCLT, the Mumbai bench of the NCLT, observed that the affidavit in reply dated 29th of November 2019 of the corporate debtor, that is JKCC, admitting the liability and stating that corporate debtor is not in a position to repay its debt, establishes the existence of a debt and its default. It further noted that there were talks about settling the matter. However, on 7th of January 2020, the counsel of JKCC appeared before the bench and said the settlement talks had failed. Now, what is important to note and what the Mumbai bench of the NCLT has observed that at the hearing held on 7th of January 2020, learned counsel appearing for the corporate debtor, that is JKCC, appeared and submitted that he has instructions to admit the liability. Thus, the liability is admitted by JKCC. So, the NCLT further observes that the application made by the operational creditor, that is MCC, is complete in all aspects as required by law. It clearly shows that the corporate debtor, JKCC, is in default of a debt due and payable. And the default is in excess of the minimum amount of rupees 1 lakh stipulated under Section 4, subsection 1 of the IBC at the relevant time. Let us pause for a minute out here and look at Section 4, subsection 1 of the IBC. Section 4, subsection 1 of the IBC states that this part, that means the part which this refers to, and that part is the insolvency resolution and liquidation for corporate persons, shall apply to matters relating to insolvency and liquidation of corporate debtors where the minimum amount of default is rupees 1 lakh. Of course, the central government may by notification specify the minimum amount of default of a higher value, but this will not exceed rupees 1 crore. Back to our case, after the petition was filed, reply was given, NCLT Mumbai bench stated its observations. It finally pronounced its order on 18th of September 2020. The bench concluded that the default stands established and there is no reason to deny the admission of the petition. It therefore ordered that the petition bearing CP IB number 3918 of 2019 filed by Puran Singh Vijay Singh Rathod, sole proprietor of Meghna Kalakem, the operational creditor, under Section 9 of the IBC, read with Rule 6.1 of the IBC Application to Adjudication Authority Rules 2016 for initiating corporate insolvency resolution process against JKCC, the corporate debtor, is admitted. Now, we pause for a bit and take a quick look at Rule 6, Sub-Rule 1 of the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016. Now, according to Rule 6 Subrule 1 is basically for applications made by operational creditors. It reads such as it reads as follows: an operational creditor shall make an application for initiating corporate insolvency resolution process against a corporate debtor under Section 9 of the Code in Form 5, accompanied by documents and records required therein, that is required by Form 5, and as specified by the Insolvency and Bankruptcy Board of India, Insolvency Resolution Process for Corporate Persons Regulations 2016. We will look at the contents of Form 5 in the upcoming video. For now, let us get back to Section 9 of the IBC. We finished with Section 9 subsection 5 of the IBC and now move on to Section 9 subsection 6. Section 9 subsection 6 of the IBC states that the corporate insolvency resolution process shall commence from the date of admission of the application under Section 9 subsection 5 of this section. Let us for a minute look at the definition of insolvency commencement date, since we are talking about the corporate insolvency resolution process commencing from the date of admission. Section 5 subsection 12 talks about the insolvency commencement date. It says that the insolvency commencement date means the date of admission of an application for initiating corporate insolvency resolution process by the adjudicating authority under sections 7, 9 or section 10 as the case may be. Now, in our case, the corporate insolvency resolution process was initiated by Meghna Kalakem, which is an operational creditor of the corporate debtor JKCC, and therefore it falls under section 9. So the insolvency commencement date for the corporate insolvency resolution process of JK Coil and Coatings Private Limited was 8th of September 2020. The date of admission for the application for initiating CIRP by the Mumbai bench of the NCLT. With that, we finish our video on sections 8 and 9 of the IBC.